Today is part one of the top 6 myths about revocable living trusts. My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and greater Minnesota alike. Just a reminder, if you like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. Also, a couple caveats before we get going. These videos are for educational purposes only. They are not meant to be legal advice. And secondly, we're going to be talking about Minnesota law here. So if you're in another jurisdiction, be sure to talk with an estate planning professional in your jurisdiction before you make any big decisions. Okay, so I had to break this into 2 videos because it started taking too long, but we're going to do the first 3 of the top 6 myths about revocable living trusts. Now, there's a lot of trust attorneys out there, or as I call them, trust attorneys. They're going to hate me for bringing these up, but I think it's important for you to know. So let's jump right into it. The first myth for revocable living trusts is a big one. It's that heirs cannot challenge a revocable living trust. Now, I was at a will signing just the other day, and one of the witnesses actually spoke up and said, how come you're doing a will? They're absolutely worthless. You have to do a revocable living trust. And I asked him why. And the reason that he believed this was his grandmother had a will, and he had like 6 brothers and sisters. And the will was challenged, and it turned into this big fight, and it split their family up, and it was terrible. And I feel for him. But I had to correct him and say, just because you have a revocable living trust doesn't mean you can't challenge the instrument. There is nothing magically written into a trust that keeps people from opposing it. If people are going to fight, they're going to fight whether you have a will or a trust at all. Now, let's look at this a little bit deeper. Wills are challenged or must be challenged under one of several legal bases. We'll take the top 3. The will is created by fraud, the will was created under duress, or the will was created under undue influence. If you look at the statutes for trusts, Minnesota statute 501c.0406, it states that a trust is void to the extent that its creation was induced by fraud, duress, or undue influence. And I would say that means that a trust can be challenged for these legal bases. And I would say that a trust can be challenged for any of the legal bases that we challenge a will under. Now, there is put some caveats on this, and this is the notice requirement. Under wills, you are required to give notice to all interested parties, and an interested party will include somebody who has been disinherited. So if you try to disinherit your son for some reason, you haven't seen him in 25 years, etc., they still get notice of the probate, and that means they can come during the probate proceedings and challenge the will. However, trusts, you don't have to give notice to all interested parties or what would be an interested party for the will. So if you've disinherited your son or daughter, they don't have to have notice. However, there is an issue with statute of limitations. For a will, to challenge the will, if you're given notice, you must challenge the will during the probate process, which means you have to challenge it between the 6 and 8 month time period that is the probate process. With a trust, however, you are required to challenge it under Minnesota statute 501c.0605a either within 120 days of receiving notice, or if you didn't get notice, you have 3 years to challenge the trust. So therefore, if someone's going to challenge, you could have it hanging over your head for 3 years after the death of the individual that you could have the trust challenged. And from my experience, if you have 2 brothers and one of them earned or gets from an inheritance $3 million, the other one will probably figure it out and learn that there is a trust to challenge within 3 years. So you probably are not avoiding a whole lot of pain by doing a trust. Let's move on to myth number 2 and 3. Myth number 2 is revocable living trusts save money on income taxes. Well, if you've watched any of my other videos, trusts are basically a legal fiction that we create. It's essentially creating a box. You put your stuff in the box, and once your stuff is in the box owns your stuff. But you own the box, and ergo, you own the stuff that's in the box. Now, for purposes of probate, you don't own anything, and the box owns everything. But for the purposes of the IRS treats the revocable living trust as if it doesn't exist. So you are not going to save any money on income taxes with a revocable living trust. Myth number 3, and the final one we'll get to today, is that revocable living trust protects your assets from Medicaid or medical assistance clawback. So what I'm talking about with Medicaid clawback is that if you go on Medicaid, they require you to impoverish yourself to, say, for example, so that you only have $3,000 of assets and only have an income of up to the poverty line or 3 times the poverty line. So it'll be about $1,000 to $2,000 a month. Now, that's a lot. So if you want to go on Medicaid, they actually take from your assets until you have drawn down to that amount. What you can do in some states is you can put your assets into a Medicaid asset protection trust. You must do this 5 years before you go on Medicaid. So let's ignore the fact that you have to know 5 years ahead of time when you're going on Medicaid. But if you do that, then your assets are protected from Medicaid, and you can earn an income off of the assets while you're on Medicaid, which brings you up to the income maximum, but doesn't kick you off Medicaid. Now, in Minnesota, you can't do this. There were some changes in the law in June or July of 2021 when the appeals court heard the Gayham case. The law is still developing in Minnesota. I'm waiting to see how that falls out, but essentially you can't do it in Minnesota. But here's the point. To do a Medicaid asset protection trust, you must create an irrevocable trust. This means you can't change the terms of the trust. A revocable living trust is not irrevocable. It's by name revocable. So it will not protect your assets from Medicaid clawback. Now, if you're smart and you live in one of the jurisdictions that allows you to do a Medicaid asset protection trust, you can set up a revocable living trust so that when you pull a trigger, it turns into a Medicaid asset protection trust down the road, and it can save you some time and money and heartache. But 2 very different things. Okay, so that's 1 through 3 of the top 6 myths about revocable living trusts, in no particular order, by the way, but it's part 1. If you liked today's video, please feel free to smash that like and subscribe button. It really helps support the channel. If you did like today's video, we do a new video every other Wednesday, so just keep an eye on the channel and it can help you out. If you have any questions or comments, leave them in the comments below. Otherwise, until next time, this is Gregory Singleton with Signature Law.